hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain...
Welcome back to the next episode of BCLS Just Law Podcast. I'm Tom Blakely. We're joined today by two students to talk about moot court is what we're going to be chit-chatting about. Bobby Ferullo and Jamie Ehrlich, both 3 L's, all 3 L's here, so 3 LOL. Guys, how you doing?
Doing great.
Awesome.
Thanks for having
Wonderful.
us on.
Thanks for having us on, Tom.
Yeah, sure. Well, before we get into it, why don't you just tell us a little bit about yourselves, what brought you to law school, how it's been going, what you've been up to, and yeah, take it away. Jamie?
Yeah, my name's Jamie Ehrlich. I'm a 3L. I'm from Marblehead, Massachusetts. I went to undergrad at the University of Chicago, took 2 years off, was a journalist, and am thrilled to be here today and almost graduating, and I think we're both pretty excited to graduate at this point.
Bobby?
So I'm Bobby Ferullo. I'm originally from Woburn, Massachusetts. I went to undergrad at Duke University. And 2 years before law school, I taught in Springfield, Massachusetts, and now I'm a 3L. Ready to start working again. It's been great here at BC Law. I'm happy to be on the podcast.
Awesome. Yeah, I heard a rumor you're a BC High guy, too.
Absolutely.
Oh, yeah.
Roundabout double eagle.
Class of 2015 right there. All right. Well, so for the uninitiated, what is moot court? Why don't you tell us about what it is, how it works, what it means in law school, and why you guys were interested in it?
Yeah, so moot court is basically a simulation of an appellate argument. So the students are given a prompt. The way that Grimes works, at least, is that you're given a prompt at the beginning of the semester, and it's usually a constitutional issue, and you're told you work with a partner and you write a brief and you prepare the brief, and then you go into rounds of oral argument as well. So Bobby and I chose to be partners after we were partners for mock trial, and kind of did the whole process together.
And so this was last spring, right?
It was, yes.
Okay, all right. And so how long did it run from when you started to when you were done with it?
Yeah, so I think the info sessions were late January, so pretty early in the semester, and kind of based on how far you get in the competition is how long it runs. So because we ended up winning it took basically the entire semester.
Oh, I see. All righty. So I guess what was it comprised of? What was the work? What were you guys doing on a regular basis? Why don't you talk to us about that?
Sure. So the big hurdle is at the beginning. It's a brief. So the brief can be anywhere from about 15 to 30 pages. And so the brief is pretty much your 1L, pretty much your legal argument brief. 1L you did, but this time it's much more.
So when you say 1L, you mean like LP? When you did it,
exactly.
Okay.
So that's what I was looking for.
Okay.
LP.
So is this like the office memo or the sort of the argument?
No. Second semester argument.
Right. The hardcore one.
Put all the persuasive words you can in there.
Right.
And you get to get a little fiery.
There you go.
And more fun.
And you get to pick what side you want for the brief.
Oh, interesting.
And so you have about 2 weeks to write it. And so one person writes the first issue, one person does a second issue, and then you turn that in. And that's how kind of your ticket to be a part of the competition. So that's really the big hurdle. And then after that, there's a practice round where you kind of get your feet underneath you. And throughout the competition, you don't decide which side you are, the appellee or the appellant, but rather they kind of decide for you. And regardless of what you wrote about, you can get both sides. So you really have to know both sides of the argument really well.
So at the beginning, you pick the side you want to represent in the brief, but then throughout, you don't get to pick which side of the case that you're on. Is that right?
Exactly.
Okay, interesting. Now, when you're talking about writing a brief, that initial brief, talk to us about what was that about? What was it on? I know through a lot of our classes, there's just the most random and arcane topics they can seem to find. But what was that on?
So this was about sanctuary cities last year. So it was a really interesting topic. There was a spending issue as well as a commandeering issue. So it was really con law plus a lot of civil procedure issues as well. And so I really enjoyed writing about that topic. I think this year it's a criminal law issue. So it should be a good topic for them to write about.
Okay.
Yeah, and it's great because it's 2Ls writing the briefs, and they just learned con law and they just learned crim law last year, and hopefully are continuing it. So it's fresh in your brain. I know we both took a lot of our experiences with Professor Farman in con law when we were writing our briefs. It really informed our arguments.
Now, who is moot court open to?
It's open to all 2Ls.
Okay, all 2Ls.
And you write the brief, and then you're able to go. So all 2Ls.
Now, throughout the litigation process, how much of that is represented in moot court? Are you doing oral arguments? Sounds like you've already talked about written. How much do you get to do?
So you get to write the brief as well as give the oral argument in front of the judge.
Interesting. Awesome. Now, what was your final case about as you progressed to the later innings of this?
So it's basically it's the same case throughout the entire thing.
Okay.
So you're basically, once you get to the final, you've argued the same case from each side
Okay.
multiple times, which makes it so by the end, everyone is really good. We had some formidable opponents
Yeah.
in Abigail LaFontaine and Andrew Dubsky, who were both phenomenal.
Yeah, so that's what I want to ask you about next. So tell me about your opponents. Like it sounds like you said they're formidable opponents. I imagine to get to the later rounds of this, you'd probably have to be. What was it like working across from them, perhaps with them? What were they like?
Yeah, so it was actually funny. So Bobby and I went up against Andrew for mock trial, so we had an idea of how great he was at oral advocacy. And I think we were both nervous just because they're so close, and we know how much they prepared as well. And that final round is in front of we had a federal judge, a superior court judge, and a district attorney who were judging us. So when you're up against someone who is so fantastic, and you're being judged by these kind of high-profile people, it is a little nerve-wracking, but we got through it.
Now, how much was it all in person? Was there some of this that's on Zoom? I know like a lot of our experience in law school has been like Zoom, court hearings and things like that. How did it work?
So it was entirely on Zoom.
Okay, entirely.
We were hoping to get the final rounds of the semifinals in person, but we did the entire thing on Zoom.
Okay.
And it was definitely a different experience being on Zoom, just because you're on your computer screen, she's on her computer screen, the other side's on theirs, and then you have the judge, as well as the bailiff. And anybody in the competitions knows there's always that extra person that has to join. And so it was on Zoom, and so...
bailiff wasn't like sending you to a breakout room or anything.
No, exactly. And so it was a different experience because, one, you have the temptation of just wanting to have your notes up there and read, but the judges can tell they want to see you as if you were there in person. And so you had to really get off those notes, really don't look at your notes during the argument, but pretend you're right there in front of the judge. So it was kind of a learning curve there being on Zoom.
Sure. So of course, many lawyers today have to, have Zoom court hearings to this day. This is sort of part of the world that we live in now. Like, can you tell us a little bit more about what that was like? Some challenges you encountered. You talked a little bit about notes and not wanting to look like you're looking at your notes, which there's something of an analog in the offline world where you might have notes with you in court. What was that like trying to perfect your oratory abilities while you're talking through Zoom?
Yeah, I think it was a challenge just kind of emotionally connecting with the person you're talking to. But I would say that the biggest hurdle was in moot court oral advocacy, the judges interrupt you with questions and you kind of have to think on your feet. And with Zoom, it cuts out when someone interrupts you.
Like a delay.
Yeah, there's a delay. So it was always a little awkward kind of getting back into your argument after you asked a question. If it was kind of a hot bench and they were asking you those questions in the middle of your argument.
Now, just to go in, perhaps I've missed it, but the sanctuary case, was that your final case that you argued? So what were some of like the main issues, the sticking points, the things that came up in your final hearing? You talked about the hot bench dynamic, like things that came up in that case that were particularly difficult.
So the main issue there's two different issues, each to our own. Our main issue for me was commandeering and whether or not the federal government can tell a municipality that they can't pass a law. And so I know it's a bunch of double negatives there, and that's something we had to work out on how to say. Okay. But essentially the federal government said you can't pass any laws.
The state can't.
The municipality, which is an extension of the state.
Right.
The municipality can't pass any laws that restrict their police officers or any city official from interacting with the federal government. And so try to wrap your mind around that. There's a lot of common law.
A lot of hours.
But as you can see, he got it.
Oh, yeah. It's
still in his brain a year later.
And but you think about ring some bells about constitutional law cases, but there's no common law case exactly like that. So you have to kind of derive your argument from the other cases that are all just slightly off. They don't say the exact same thing. And then conversely, it was an immigration case. Who has the power to regulate immigration? The federal government. And so both sides had pretty good arguments. But for the final round, we were the city of St. Claude, whatever it was called.
It was different every
round.
It
was different every time.
Jurisdiction,
and so, so each time we picked a side, I like being the federal government sometimes because you get up there and say, "Hi, my name is Bobby Ferullo, and I represent the United States of America."
Oh, yeah.
And so pretty cool.
Yeah, it sounds better.
Sounds cooler as you say in the
so
city
official,
of St. Yeah, exactly. But for the final round with the city of St. Cloud saying,
Okay. Not quite as official.
no, and so the federal government can't come in and tell us what we can
Yeah,
pass.
they're
at our
not
city
shaking
level.
in their boots because of St. Cloud is in the courtroom. Now, you said that each of you had an issue. That was yours. So, Jamie, what was your issue?
Yeah, mine was a spending clause issue. So it was an argument very similar to the one that Justice Roberts made in the Affordable Care Act case, Sebelius. So it was basically whether or not the federal government could pass a law that withheld funds if they didn't comply with federal law. So whether or not them threatening those funds was a gun to the head of the municipality, and whether or not the municipality had a real choice when choosing or whether or not to implement certain policies of the federal government.
Gotcha.
And I would say, I mean, I'm generally a liberal person. It was difficult at times arguing on behalf of kind of a more conservative federal government when kind of dipping into the sanctuary cities issue for sure.
Now, what advice would you give students who are going into moot court now and the future, based upon your experiences?
Let the future litigator take that one.
Yeah, I would
Big corporate
say,
guy over here.
I think one of the most important things is to find a partner who you can work long hours with and who you trust to kind of get their side of the argument down. I think you're doomed to fail if you don't trust your partner. And Bobby and I worked really well together. We wrote the brief 50-50 and always kind of got the same feedback like throughout the entire rounds. The judges would always compliment both of us, and it was a very balanced experience. Whereas if you're spending these long hours with a partner and they're not pulling their weight, you start to resent them. It never ends well. So definitely find someone you trust, and also just have fun. I think it can be a really stressful experience if you make it one. I think there were definitely times where we were stressed out, but it ended up kind of ending well, and we look back and remember very fondly the time we spent preparing.
Awesome.
Yeah, and echoing what Jamie said, definitely having someone that you can work with well. You're going to spend a lot of time together preparing the arguments. And the other thing I want to add is know your argument very well. It's a different experience. The only kind of experience you have with oral arguments is your 1L quick 10-minute oral argument. But when you go to the first practice round and you don't know your argument perfectly well, you kind of get knocked back a little bit. The only way you can really stand on your feet and have an argument, know what you're talking about, is if you really know the argument. I haven't really had the opportunity. I was a teacher, but that's kind of a different type of thing where I control the classroom. I'm telling students what we have to do. They're asking questions. I can give answers. I ask them questions. But when you're the person standing in front of the judge, not knowing what they're going to say, you can have some question that you don't know, and you better know your argument well, or else you're going to have a lot of and just give the wrong answer. And even worse than stopping for a little while and giving a lot of ums, definitely stop and think. But the worst is if you give a wrong answer, and some judges really like to pound you and put you into a corner.
Sure.
And so definitely knowing your argument backwards and forwards will allow you to have the ability to answer those tough questions because they're going to come. And that's a little different from mock trial where it's kind of you have your line of questionings for the witnesses, for cross-examination. But with moot court, you don't know what's coming any given night. And so the judges can ask you a question you've never seen before, and you have to really know your argument or else you're really going to get caught off guard.
So going off of that, you talk, Jamie, you mentioned feedback, and obviously you're talking about, there's some, sounds like there's some hard coaching you might have to take at times if you don't know things backwards and forwards, as you said. Can you talk about, the feedback, like what you guys got? Maybe there's some of those moments like you're alluding to, like how that, impacted you preparing in the future?
Yeah, Bobby and I are both thinking of the
I see you smirking. There's something going on.
We had one judge who was so tough on us, and he was tough on the other side too. I think that was just his style. And it really, it both stunned us. We both logged off the Zoom and immediately called each other and said, would you believe what just happened? But at the end of the day, it makes you better. And I think you really have to learn to take feedback gracefully. And it definitely, I remember he said, he was pounding us with questions, and Bobby and I just both started smirking.
What kind of questions?
I mean, the questions were, what do you mean? How, how are you saying this when their argument goes the other direction? And, when you're giving
it's
a losing
leading,
argument. And we both started kind of smirking because we were like, I can't believe this. And during feedback, he said, "You guys were smiling. What were you smiling at? It comes off as so rude." And for the rest of the rounds, we were stoic.
Yeah.
There was no.
So he rattled you a little bit there. Yeah.
Oh, yeah.
Yeah.
Okay.
But that was an early round, luckily. But we both remember it so clearly at this point.
Yeah, and we have to be grateful to the BC Law alums that do come and judges competitions, because this is a big night for them. A lot of them, some judges don't, but a lot of them do show up knowing the argument very, very well, and they prepare very well, and they want to give you feedback. So a lot of the alums that come back and judge, whether they're actual judges or they're lawyers that are litigators or corporate lawyers as well, they come to that night knowing the arguments very well and ready to give you feedback. And so it is really great feedback because they all do come very prepared and want to help you out.
Awesome. I would also say some of them are real judges. So these are people that, I mean, I don't know if you're going to be doing a lot of litigation in your job, but these are people that we're actually going to be arguing in front of starting next year. So it's great preparation, and there are BC Law alums all over Boston who are judges, so it's just a great experience.
Authentic feedback. Now with the tough person that you mentioned there, did that fall evenly? If you were there for it, did the other side get the same level of scrutiny, perhaps?
Oh yeah, absolutely.
Yeah.
It was a tough night all around.
Yeah.
Okay, tough night for everybody.
And we won that round, so it wasn't horrible feedback, but we both got kind of.
Yeah.
Jamie carried me that round.
Sure. Well, finally, before we wrap up, what if you could change something about moot court, or if you were sort of overseeing this in the future from your experience, what do you think could be improved? What do you think maybe if it was a little different might be better?
Let me think about that one.
I mean, I obviously wish it had been in person, and luckily this year, which now I'm talking directly to the 2Ls, you should absolutely do it. But it's a great experience to be standing up and giving the argument. And unfortunately, due to COVID, we were on Zoom, but I think that it would have been great if we were in person.
Yeah, I just echo it being in person with the only thing I can change. I know Ryan Moser, the head of BSA, did a wonderful job running all the competitions. And so
He runs everything.
Yeah, no, that's what I'm saying. He runs all the competitions. He did a great job last year. I know there was 3Ls in particular that ran the moot court. Their names are escaping me right now, but BSA does a great job putting these competitions on.
Awesome, very good. Well, this has been BC Law's Just Law podcast. We've been chatting about moot court. I'm Tom Blakely talking to Jamie Ehrlich and Bobby Ferullo. Until next time, that'll do it. Thanks for tuning in.